Good afternoon, class. Yesterday I have started with a new chapter, Fundamental Rights and Duties. So I'm continuing with the same chapter. Chapter 3, Civics, page number is 26. Yesterday I have explained up to freedom to assemble peacefully, and it came under Article 19. So today first subtopic is freedom of association. It's also come under Article 19. Article 19 of the Indian Constitution also granted to the citizen the right to form association or union. It's given them the right to not only start any association but also to continue it, to refuse to be a member of it if the citizen wishes to do so. It also gives the citizen right to dissolve the association after its formation. So Article 19 of the Indian Constitution is also granted to the citizens to form an association. To form association and union, it's also given them right to not only start the association but also continue the association. Even they have the right to refuse to be a member of the citizen if they wishes to. Even the citizens of India has the right to dissolve the association after its formation. There is some restriction for this freedom to association. Like the freedom of association, like other freedom, is not absolute or unlimited. So this freedom of association, like the other freedom, is not absolute or unlimited. The government can pass laws to impose reasonable restriction on this freedom on the following grounds. So even the government of India can pass laws to impose reasonable restriction on this freedom on the following grounds. First one is sovereignty and integrity of India. Second is public order and morality. The government of India can impose this reasonable restriction under freedom or under article under freedom of association. Significance of the freedom of association. The framers of the Constitution granted the freedom of association to the citizen because every human being is a social animal and its basic nature to mix with human fellows having similar ideas. Moreover, the employees and peasants often suffer at the hands of the employers and the zamindars. They were not allowed to form organization to seek justice. So the significance of the freedom of association is the framer of the Constitution granted the freedom of association to the citizen because every human being is a social animal and it is the basic human nature to mix with the fellow human beings having similar ideas. Moreover, the employees and the peasants often suffer from the employers and the zamindars, so they were not allowed to form organization or seek justice for their rights. Next is right to move freely throughout the territory of India. So this freedom of movement means that as a citizen of India, we can travel anywhere in India without any restriction or for purposes of trade, business, employment, pilgrimage or sightseeing. So as a citizen of India, we can travel to any part of India without any restriction for trade, business, for employment, for pilgrimage or sightseeing. Even this freedom to move freely throughout the territory of India has some restriction. The restriction of this freedom are on the following grounds. First is in the interest of public order. It should be on the interest of the public order, for the protection of the interests of any scheduled tribe. So it should be protection on the interest of any scheduled tribe. Citizen entry can be restriction in prohibited area for security of the state, for military purposes, for security of government projects. So though we can move freely in any part of India, but there are some restriction on prohibited areas like the security of the state. Therefore, like some of the militaries area we are not allowed to enter, and for the security of the government project, etc. Next is freedom to reside and settle in any part of India. Every citizen of India has the right to reside. They can reside any part of India. The right is an elaborating of the right to freedom of the movement with the territory of India, and object of the right is to remove internal barriers. So as a citizen of India, we have the every right to reside any part of India, and this freedom to reside or settle in any part of Indian territory have some restriction. First is in the interest of general public order. So it should be in the interest of the general public order. Second is for the protection of interest, and for its even this is also same as the right to move freely throughout the territory of India. Same point for the protection of interest of the saddle tribe. Next is on the ground of espionage, disloyalty and similar of other charges. These were the restriction on the freedom to reside and settle in any part of Indian territory. Next is freedom to practice any profession or to carry on the occupation, trade or business. So the Constitution of India had guaranteed to the citizen of India that every citizen has the right to choose their own employment, practice any profession, carry on any trade or business. So as a citizen of India, we can choose any employment, practice any profession. As I told before, that we can be a doctor, engineer, teacher, and we can take up any business like hotel business, or we can open shop anywhere. So it is our own right, but the right does not allow the citizen to but this right does not allow the citizen to carry on harmful activities. So though we have given the right, but this right does not allow the citizen to carry harmful activities such as betting or gambling, dealing in intoxicating drinks and drugs. Even this freedom to practice any profession or to carry on the occupation, trade or business has some restriction. It is also same. It should be in the interest of the public, general public. Next is the state may by law make condition for carrying on any profession or technical qualification for carrying on any occupation, trade or business. Next is the state may by law enable it or a corporation owned by a controlled by a state or to carry any trade or business and exclude the citizens from these areas completely or partly. Next is right to protection of life and personal liberty. Article 21. It's come under Article 21 of the Indian Constitution, guaranteed that to its citizens that no person shall be deprived of his life of personal liberty. So the Constitution of India has guaranteed that the citizen that no person shall be deprived of his life or personal liberty according to procedure established by law. This means that the person can be punished, imprisoned or subjected or physical only according to the procedure established by law. Only that person can be punished, imprisoned or subjected according to the procedure established by law. Significance of this right to protection of life and liberty. This is a right that prevents the executive from interfering with the personal liberty except by lawful means. So the significance is that this right can be prevent the executive from interfering with the personal liberty except his lawful means. Next is right to protection in respect of conviction for offences. So according to Article 20 of the Constitution, no person shall be punished on the same offence more than once. So no person shall be punished for the same mistake they have done before. So in the simple term we can say that no person shall be punished for the same offence more than once. Secondly, no person accused of an offence shall be compelled to be a witness against himself. So no person can be accused of an offence shall be compelled to witness against himself. Next is right against arrest and detention. Article 22 of our Indian Constitution provides for protection against arrest and detention in certain cases and lay down the procedure that must follow once a person that have been arrested, and it should be in held custody without trial. So Article 22 of our Indian Constitution states that for protection against arrest and detention in certain cases that lay down that must be followed. That once a person have been arrested and held in custody without a trial, these articles state that the following: no person who is arrested shall be detained in custody without being informed as soon as may be of the ground of such arrest, shall not be denied the right to consult to be defended to a legal practitioner of a judge. So if a person is arrested, he has the legal right to consult and confided to the legal practitioner of his choice. Prevention detention. Article 22 of the Indian Constitution gives power to the Parliament to enact preventive detention. So preventive detention, it's come under Article 22 of the Indian Constitution. It's give power to the Parliament to enact preventive detention laws. Preventive detention means detention of a person without trial. So the Parliament can enact preventive detention laws for the following reason. First is that it should be the security of public order. Number B, maintenance of supplies and services essential to the community, defense and foreign affairs. Next is right against exploitation. Before independence, beggar or bonded labor was prevalent in many parts of the country, especially in the princely states. In holy places, women are exploited by the religious authority under the Devadasi system. Women are dedicated to the gods and religious places. So this right to against exploitation means even before independence, beggar or bonded labor was prevalent in many parts of country, especially in the princely state. In holy places, women were exploited by the religious authorities. As before the independence, as there was a system of Devadasis where women were dedicated to the gods and religious places. The framer of the Constitution acknowledged that this practice as not only inhuman and barbaric but against human dignity. So the framers of the Indian Constitution acknowledge that the practice of Devadasis is not only inhuman and but it's also a inhuman and barbaric, but it's also against human dignity. So therefore they laid down in Article 22 of the Indian Constitution that trafficking human beings and beggars and other forms of forced labor were prohibited and exploited, and violation of this provision is an offence punishable in accordance with law. So according to Article 23 of the Indian Constitution, that trafficking of human beings and beggars and other similar forms of forced labors were prohibited, and it's a violation to its provision. So it's a offence and it's punishable in accordance with law. Next is prohibition of employment of children. To protect children from hazardous employment in unhealthy condition, Article 24 of the Constitution said that no children below the age of 14 shall be employed in any factory or mine or engage in any dangerous employment. So provision of employment of children, to protect the children from deadly employment in unhealthy condition. And under Article 24 of the Indian Constitution said that no children below the age of 14 years shall be employed in any factories or mine or engage in any dangerous employment. Significance of Article 23 and 24. These two articles do not prohibit complete exploitation of men by every possible manner. So it implies that exploitation must be against human dignity, and social justice should be prevailed in society as reflected in the preamble. So these two articles did not prohibit complete exploitation of men by every possible manner. So it implies that exploitation not be against it should not be against human dignity, and social justice should prevail in society as reflected in the preamble. Next is right to freedom of religion. Article 25 granted that right to freedom of conscience and religion and declared that every person shall has the right to profess, practice and propagate any religion. So this freedom is granted to all citizens and foreigners alike. Next is freedom to manage religious affairs. It's come under Article 26. It's give freedom to religious group of the denomination of India. First one is to establish and maintain this. They have the right to establish and maintain institution for religious and charitable purposes. Next is to manage. They have the right to manage their own affairs of religious matters. Next is to own and acquire movable and immovable property. They have the right to own and acquire movable and immovable properties. Significance of article freedom of manage religious affairs. Freedom to religion was made a fundamental right because from the Hindus who from the majority of Indian population, other minorities communities such as Muslims, Sikhs and Christians require constitutional protection for their religious sentiments. So significance for this freedom is as a freedom of religion was made a fundamental right because apart from the Hindus who had the majority of Indian population, other minorities communities like the Muslims, Sikh and Christian, they have required constitutional protection of their religious sentiment. Secondly, this fundamental right is an implementation of the ideal of secularism which was included in the preamble. Next is freedom from of the payment of tax for promotion of any particular religion. So Article 27 said that no person would be compelled to pay tax the proceeds of which is specifically appropriate in payment of expenses of the promotion of any particular religious denomination as this Article 27 said that no person should be compelled to pay taxes that proceeds of which are specifically appropriate in payment of expenses for the promotion of the maintenance of the religious denomination. Next is freedom to attend religious instruction of religious worship in certain educational institution. It's come under Article 28. So it mentioned that no religious instruction will be imparted in any educational institution wholly maintained out of the state fund, which is different from institution receiving government aid. So Article 28 mentioned that no religious instruction should be imparted in the educational institution wholly maintained out of the state fund, which is different from the institution receiving government aid. Next is cultural and educational right to give adequate protection to the interests of the minorities, in particular to nurture the multilinguistic and multicultural character of India society. Article 29 and 30 were incorporated dealing with cultural and educational freedom. So right to conserve one language, script and culture, it's come under Article 29A. State that any section of the Indian citizens having a distinct language, script or culture of its own shall have the fundamental right to protect the same. So Article 29(1) state that any section of the Indian citizen having a distinct language, script or culture of its own shall have the fundamental right to protect the same. This means that all minorities can preserve their culture and the state cannot deprive from this right. Next is right to establish institution. It's come under Article 30 says that all the minorities have the fundamental rights to establish and maintain educational institution of their choice. Next is right to education. The 86th Amendment 2000 of the Indian Constitution added new Article 21A after 21. According to this article, the state shall provide free and compulsory education to all children of age 6 to 14 in such manner as the state may by law determine. So right to education, it's the 68th Amendment 2000 of the Indian Constitution added a new Article 21A after Article 21. So according to this article, the state shall provide free and compulsory education to all children who has age of 6 to 12 years in such a manner as the state law determine. The Right to Education Bill was passed by the Parliament and on 4th August 2009 and it came into force on 1 April 2010. Thus, the right to education became a fundamental right enjoying equal status with other rights like the right of life and sixth freedom under the Constitution of India. So, the features of Right to Education Act are Right to Education Act has the following feature. It's aim to provide free and compulsory education to all children between 6 to 14 years of age. Second point, no child shall be held back, expelled or required to pass a board examination till class 8. So, no child shall be held back, expelled or required to pass board examination till class 8. Next is, there shall be 25% seat reservation for poor and weaker section of the society in private and minority schools. So, there shall be 25% seat reservation for poor and minority for poor and weaker section of the society in private and minority school. Untrained school teacher must be obtained the requisite teacher degree within 5 years. So, untrained school teacher must obtain the requisite teaching degree within 5 years. Those teachers are not trained, they should obtain the teaching degree within 5 years of their joining. Next is Right to Information 2005. The Right to Information Act was passed by the Parliament in 2005. According to this Act, the citizens have the right to secure information from the government offices, public and financial institution and public sector undertaking of any document and record. The concerned authority is required to reply within 30 days from the date of receipt of such request. So, all public authorities are required to appoint a public information officer for this purposes. So, this Right to Information Act was passed by the Parliament in 2005. So, according to this Act, that the citizen of India has the right to secure information from any government offices, public and financial institution and public sector undertaking on any document and record. So, the concerned authority is concerned authority has required to reply within 30 days from the date of the receipt of the complaint. So, all the public authorities are required to appoint the Public Information Officer (PIO) for this purpose. If the information concerns the life and liberty of the individual, it must be replied to it in 48 hours and 45 days in case of human rights violation. So, if the information is concerned about life and liberty of the individual, it must be replied within 48 hours of the complaint and within 45 days in case of human rights violation. On January 12, 2009, the Delhi High Court ruled that the right to information was a fundamental right and the Chief Justice of India was also covered by this Act. So, on January 12, 2009, the Delhi High Court ruled that the right to information was a fundamental right and the Chief Justice of India was covered by this Act. Next is Right to Constitutional Remedies. The fundamental rights granted to the Constitution are the foundation of democracy, but their mere inclusion is meaningless unless there is a strong provision for their protection. So, right to constitutional remedies, the fundamental rights granted to the in the Constitution that all the foundation of democracy, but it's a mere inclusion in them. It is meaningless unless there is a strong provision for their protection. So, the framers therefore made the Supreme Court. The framer has made the Supreme Court the guardian of fundamental rights and incorporated under Article 32, which deal with the right to constitutional remedies. Article 32 state the following. So, under Article 32, every person shall have the right to move the Supreme Court by lawful means for the information of enforcement of the public rights contained in Part-3 of the Constitution. So, every person has the right to move to the court means to the Supreme Court by lawful means. So, for the enforcement of fundamental rights contained in Part 3 of the Constitution. Even the Supreme Court shall have the power to issue order, direction and prerogative writs for the enforcement in fundamental rights. In the next class, I'll be explaining about the writs issued by the Supreme Court. So that's all for today. Thank you.